Welcome back to Google class. Today I am going to discuss with Indian Penal Code under section 309. Okay. Here section 309 explain about attempt commit suicide. Attempt commit suicide. Section 309 explain this attempt commit suicide is whoever attempt to commit suicide and does any act towards the commission of such offence shall be punished with simple imprisonment for a term which may extend to 1 year, or with the fine, or with the both. Okay, this section only 1 year punishment. Here the act suicide by itself is not an offence under either English or Indian criminal law. Though at one time it was a felony in England, it is a unique legal phenomenon in the Indian Penal Code that the only act, the attempt of which alone will become an offence. The person who attempts to commit suicide is guilty of offence under section 309 Indian Penal Code, whereas the person who committed suicide cannot be reached at all. Section 306 renders the person who abets the commission of suicide punishable, which the condition precedent is that suicide should necessarily have been committed. Okay, suicide necessarily committed. The act done must be in the course of the attempt, otherwise no offence is committed. Here, where a woman with the intention of committing suicide by throwing herself in a well actually ran towards it, when she was seized by a person, it was held that she might have changed her mind, and she was caught before she did anything which might have been regarded as the commencement of the offence. Her act simply amounted to preparation, that's all. Okay, the pounding of oleander roots with an intention to poison oneself with the same was held not to constitute this offence. Another one example where the accused jumped into a well to avoid and escape from police, and when rescued he came out of the well of his own accord. It was held that the absence of evidence that he jumped into the well to commit suicide, he could not be convicted of this offence. Clear? And another one, a village woman 20 years old was ill-treated by her husband. There was a quarrel between the two persons, husband and wife, and the husband threatened that he would beat her. Late at night, the woman, taking her 6 months old baby in her arms, slipped away from the house. After she had gone some distance, she heard somebody coming up behind her, and when she turned round and saw her husband pursuing her, she got into a panic and jumped down a well nearby with the baby in her arms. In this result was that baby died, but the woman recovered. Okay, here the one of the charges against her was attempt to commit suicide. It was held that she should not be convicted under the section of an attempt to commit suicide, for the word attempt connotes some concise endeavour to accomplish the act, and accused in jumping down the well was not thinking at all of taking her own life but only of escaping from her husband. Okay, this is what saying this section. And another example, voluntary termination of life. Some person's voluntary termination of his life, taking poison, medicine, something like, no. So that person cannot claim his own life by saving that he or she had lead a successful life and the mission of his life was fulfilled. It would amount to suicide as it would attract the provision of under section 306 and 309 of IPC. Here, this situation, the court said that no distinction could be made between suicide or ordinarily understood and the right to voluntarily put an end to one's life. Okay. And another a peculiar thing, the constitutional validity of section 309, how it is. I'll give you some case law, a leading case law. Okay, here the P. Ratnam versus Union of India case, based on the constitutional validity, section 309. The constitutional validity of 309 was challenged, and the Supreme Court observed that the provision punishing attempt to commit suicide is cruel and irrational and is violative of Article 21 of the Constitution, and it deserves to be effaced, okay, or effaced from the statute book to humanize penal law. It added that the act of attempted suicide has no baneful effect on society, and it is also not against religion, morality or public policy. Besides, suicides or attempt to commit it cause no harm to others. This decision was subsequently reversed, and it has been held again that the provision for penalizing attempt to commit suicide and abatement of suicide is not constitutional. Where the accused was convicted in 1992 under section 309 of IPC for attempt to commit suicide. Okay, and he was acquitted in view of the subsequent ruling of the division bench of the